for entry of a judgment of divorce by consent. Are you Andrea Malzoff?
Yes, sir.
Are you Dale Malzoff?
Yes, I am.
All right, would you both raise your right hands so I can see them? Each of you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Yes.
All right, you can put your hands down. Ms. Malzoff, would you state your name and your address for the record, please?
Andrea Malzoff, 244 Henry Street, Smith Creek, Michigan, 48074.
All right, Mr. Malzoff, would you state your name and address for the record?
Dale Malzoff Jr. I live at 7861 Angus Drive, Shreveport, Louisiana, 71107.
All right. Ms. Malzoff, are you married to Dale Malzoff?
Yes.
On what date were you married?
October 15th, 2005?
2005.
Is that marriage performed by somebody authorized by law to perform marriages?
Someday by law.
Was it performed by somebody authorized by law to perform marriages?
Yes, sir.
Right. Prior to filing your complaint for divorce, you resident of the state of Michigan for at least 180 days?
Yes.
You're a resident of the county of St. Clair for at least 10 days?
Yes, sir.
You've alleged in your complaint that there's been a breakdown of the marriage relationship and there remains no reasonable likelihood that union can be preserved. Is that still true?
Yes, sir.
Are there any minor children in the marriage?
No, sir.
Are you pregnant now?
No, sir.
Have to ask. Did two of you own real estate?
Yes, we own real estate.
All right, what it indicates on your judgment of divorce is that you have property on 16th Street in Port Huron and property in Shreveport, Louisiana, correct?
Yes.
And that you're being awarded the one in Port Huron and Mr. Malzoff is being awarded the one in Louisiana.
Yes.
All right. Are there debts associated with those properties?
No.
Mr. Malzoff, do you have a mortgage on yours?
Yes.
Is that solely in your name?
No, it is not. It is joint, but we'll
I
have to
wasn't.
take care of that.
What was that?
We'll have to sign the paperwork after the divorce is final. They said once they see judgment.
All right, so what I assume that to mean, Mr. Malzoff, is that you're going to refinance this into your own name?
Well, they said all she has to do is sign a form and they can drop her off the mortgage with a copy of the divorce paper.
All right, I'm going to add the language on here then is that you're solely responsible for that mortgage.
Correct.
All right. All right, I've simply added that the defendant is solely responsible for the debt on this property, and that's right after the indication that you're being awarded the property on Angus Drive in Shreveport. When did you separate?
July 1st, 2019.
All right, at that time, did you divide all of your personal property?
Yes.
Mr. Myerscough, is that correct?
That is correct.
All right. So there's nothing left between the two of you to be divided, correct?
No.
Correct.
Do you have any joint debts other than this mortgage?
No.
Well, that's it.
All right, so you'll each be responsible for any debt in your own name as well?
Yes.
Correct, Mr. Myerscough?
Yes.
All right. Do you have any retirement savings or pension plans that are going to be divided?
No, sir.
And is it true that neither one of you will pay the other spouse's support?
No,
That's
sir.
correct.
Is that correct, Ms. Mazoff?
Yes.
Yes, sir. That's correct.
All right. And are you asking to have your name changed, Ms. Mazoff?
Yes.
To what?
Andrea Lynn Wager, and it's Wagar.
Is that a former name?
It's my maiden name.
All right. Court is satisfied from the testimony jurisdictional requirements for divorce have been met. There's been a breakdown in the marriage relationship and there remains no reasonable likelihood of reconciliation. There are no minor children of the marriage and the plaintiff is not pregnant. Division of assets and liabilities will be according to the agreement of the parties. Neither party will have any interest in the other party's retirement savings plan, pension plan, or profit sharing plan if there are any. Alimony payable from either party to the other be forever barred, and the plaintiff's last name may be restored to Wagner. Both parties having consented to the entry of the judgment of divorce, I'll sign it at this time. And we'll have this filed with the county clerk's office. You'll have to make arrangements to get copies of them sent to you at your respective locations. Or actually, they'll go back to the plaintiff and she can send on to your copy to you, Mr. Myerscough.
Okay.
And then you can do what you need to do with regard to your mortgage.
All right. Thank
You're all
you, sir.
set. You're welcome. You're both all set.
Okay. Thank you.
Thank you. All right, this is a matter of, I'm going to pronounce it Lonis versus Lonis, and it's scheduled for entry of a consent judgment of divorce. Counsel, your appearances, please.
Good morning, Your Honor. Anthony Urbani, appear on behalf of plaintiff Matthew Glenn Lanus, sitting to my right.
Michelle Easter on behalf of Carolyn Lanus.
All right, I have a copy of the judgment of divorce that's not signed by anybody.
Correct.
So I'm assuming that all parties are in agreement as it relates to this settlement.
Yes, Your Honor. Good morning. Sister Counsel and I have worked on this matter to settle all issues relative to the minor children and the assets. We've circulated between ourselves several proposed judgments. The one in front of you, Your Honor, we believe is the final one. The clients have not, we did it as late as yesterday, and the clients have not thoroughly reviewed it. We believe it's the culmination of our settlement, and we understand that we're able to put the proofs on the record today and send a signed judgment to Your Honor in short order.
That is our understanding as well, Your Honor. We do agree with that.
All right.
I'd ask both Mr. Lonis and Ms. Lonis to raise their right hands so I can see them, please. Do each of you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right. Mr. Vanny, you may proceed with the proofs.
Thank you, Your Honor. Sir, would you state your name for the record, please?
Matthew Lanner?
And do you recall filing a complaint for divorce in this matter?
Yes.
And did you review that complaint?
Mr. Vanny,
Yes, Your Honor.
I can hardly hear him through the mask, and he's sitting away from your microphone. So
Thank you, Your Honor.
speak up nice and loud, Mr. Lonis.
Okay.
Okay, did you file a complaint for the case in this matter?
Yes.
And did you review that complaint before you filed it?
Yes.
And was it true in your mind?
Yes.
Is it still true today?
Yes.
One of the allegations was that you were a resident of St. Clair County continuously, immediately for 10 days preceding the filing of that complaint. Is that true?
True.
And you were also a resident continuously for 180 days in the state of Michigan continuously before the filing of that complaint. Is that true?
True.
You have one minor child and you reviewed the proposed judgment of divorce and you believe that all the provisions in that proposed judgment are in the best interest of your minor child.
Correct.
Your wife is not pregnant to the best of your knowledge?
Correct.
And you've alleged that the marriage relationship broke down to such an extent that there remained no reasonable likelihood that this marriage can be preserved.
Correct.
Is that still true today?
Yes.
If the judge was not to grant you a judgment of divorce, could you live together as husband and wife of the defendant?
No.
And you were already separated?
Yes.
The proposed judgment that you're going to be signing, but you've seen some other ones, contained in your mind all your assets and all your liabilities?
Yes.
And you believe that's a fair distribution of all those?
Yes.
Including the business interest that you have right now in two companies, correct? Okay. I have nothing further, Your Honor, with my client.
Because I don't have a signed copy of it, I want to get some more detail on this. Regarding the minor child, Mr. Lonis, the judgment I have here before me indicates that the parties will share joint legal custody, physical custody being awarded to the mother. Is that your agreement?
He's asking you. Joint legal custody, physical custody to your wife is what the judge asked you.
Correct.
All right. Ms. Easter, do you have questions of the plaintiff?
Yes, actually, I do, Your Honor, just to put a little bit more specifics on the record. Mr. Lanus, is it true that you both agreed that as related to the marital home, that Ms. Lanus is allowed to have exclusive possession of that home for the next 7 years?
Yes.
And you also agreed that during those 7 years, you would be responsible for paying the mortgage payment, the property taxes, and the homeowner's insurance?
Correct.
And Ms. Lanus will pay for all the utilities and stuff associated with the home?
Correct.
Okay. And as it relates to, one moment, please, spousal support, you agreed that there would be spousal support paid to Ms. Lanus, and that is going to be in a, I'll just say like a 2-step process. From May 1st of 2021 until September 1st of 2023, you have agreed to pay Ms. Lanus monthly $712. Is that correct?
Correct.
And then from September 2023 until May of 2024, you will be paying her $1,500 a month.
Correct.
Counsel, can we just make a record that it's non-modifiable?
Yep. And you understand that those payments are non-modifiable in both amount and duration.
Correct.
Okay. And then you are going to be awarded 100% of both of the businesses that were acquired during the marriage, and you're going to be responsible for any type of, you'll be awarded 100% of the assets, but you'll also be responsible for all the liabilities associated to those businesses. Is that correct?
Correct.
Okay. And the one of the marital assets that will be sold immediately is going to be the motor home. Is that correct?
Correct.
And then you both will equally share in the sale proceeds.
Correct.
Okay. And in the judgment that was drafted, there's a list of personal property in there. Does that reflect the property that you would like to be awarded?
Yes.
And Miss Lanus is also going to be awarded 50% of her marital share of your pension from the Teamsters Union.
Correct.
Okay. And you will also be paying $2,500 for attorney fees for Miss Lanus.
Correct.
I have no other further questions, Your Honor. Thank you.
Your Honor, I would,
Anything further, Mr. Urbani, of your client?
yes, Your Honor, I would like to ask the defendant, not for my client, but I would like to ask the defendant some questions, Your Honor.
Well, all right, we'll proceed with that at this point. Ms. Easter, your client's been sworn, so you may inquire of her.
Okay, thank you, Your Honor. Ms. Lanus, have you heard exactly what I have put on the record and also Mr. Urbani has put on the record as it relates to your property settlement agreement?
Yes.
And do you believe, based on what you read in the judgment and also what we put on the record here today, does that reflect a clear and accurate representation of your agreement?
Yes.
And do you believe that this is a fair and equitable distribution of your property?
Yes.
Has anybody coerced you or threatened you to enter into this property agreement?
No.
As it relates to, there's one minor child remaining. You have agreed that you will share joint legal custody and you will be awarded physical custody.
Yes.
And the two of you, the parenting time agreement that's displayed in the judgment, basically he will have the standard parenting time. Do you believe that's in Michelle's best interest?
Yes.
And you also understand, as it relates to the spousal support, that it is non-modifiable in both amount and duration.
Yes.
And Mr. Lanus will not be awarded any spousal support.
Yes.
And are you currently pregnant?
No.
And you're going to keep the married name of Lanus, is that correct?
Yes.
Okay. Have you disclosed throughout this process, have you disclosed all of your assets and liabilities?
Yes.
Nothing further, Your Honor. Thank you.
Sir Urbani, go ahead.
Thank you, Your Honor. Ms. Lanus, you understand, I'm sure, and your lawyer has told you that you would have had the right to ask the judge for what we call modifiable spousal support, which means it could be changed under financial changes in circumstances or other proper causes that you would ask this court to review. You understand that?
Yes.
And you had that constitutional and statutory right to ask for that and go to trial. And you may have gotten more, you may have gotten less, may have gotten the exact same thing with regard to spousal support, but it could not only be modifiable. You understand that?
Yes.
You're giving up your right by this settlement and what you placed on the record to that statutory right of modifiability. And you understand that you can never come back to this court or his successor and ask for any change or modification of spousal support. This is it. That's all. Nothing can change it. Do you understand that?
Yes.
And that's your agreement and that's your understanding.
Yes.
And one last thing with regard to the assets and liabilities, I know you said you have them all and you disclosed all of them, but they're all contained in this judgment. Is that correct?
Yes.
Okay. I have nothing further, Your Honor. Thank you.
Anything further of your client, Ms. Easter?
No, Your Honor. Thank you.
All right, the court is satisfied with the testimony. Jurisdictional requirements for divorce have been met, that there's been a breakdown in the marriage relationship and remains no reasonable likelihood of reconciliation. There's one minor child in marriage and the plaintiff is not, the defendant is not currently pregnant. Parties will share joint legal custody of the minor child, physical custody be awarded to the defendant mother. Court finds, based on the testimony of both parents, that this is in the best interest of the minor child. Division of assets and liabilities, recording agreement of the parties, qualified domestic relations orders as necessary may enter to carry that into effect. The alimony provision is approved as being non-modifiable as both parties waive their statutory right to have it modified. And the judgment of divorce consistent with this record and the agreement of the parties may enter. and it must be reviewed and approved by the front of the court. So you're all set.
Thank you for your
Thank
time,
you, Your
Your
Honor.
Well, Ms. Easter, do you know if the defendant is going to be attending?
I don't believe so, Your Honor. You should have a signed judgment in front of you.
I do.
He's aware of it.
All right, I'm gonna wait till our clock here shows 10:45 there, just in case he wants to log in.
Okay.
All right, this is a matter of Hobig versus Hobig, and it's scheduled for entry of a consent judgment of divorce. Ms. Easter, you want to put your prints on the record?
Yes, thank you, Your Honor. Michelle Easter on behalf of Sharon Hobig.
Are you Sharon Hobig?
Yes, sir.
Would you raise your right hand, please? You solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, you can put your hand down. Go ahead. Ms. Easter, you may proceed.
Thank you, Your Honor. Ms. Hobig, can you please state your name and spell your last name for the record, please?
Sharon Elaine Hobig, and it's Hobig.
And Ms. Hobig, is it true that you were married February 27, 2013 to Richard Hobig?
Correct.
And originally you had contacted me. We filed a divorce complaint on December 11th of 2020. Is that correct?
Yes.
And at the time that we filed the divorce complaint, Mr. Hobig was a resident of the state of Michigan for at least 6 months and a resident of the county of St. Clair for at least 10 days. Is that true?
Yes.
And when we discussed the different types of allegations in that complaint for divorce, you had indicated that there is now a breakdown in the marital relationship to where the objects of matrimony could no longer be restored. Was that statement true back in December?
Yes.
Is that statement still true today?
Yes.
Okay. And actually, originally, we were in this courtroom back in October of 2017, where the Honorable Judge Brown had entered a separate maintenance between you and Mr. Hobig. Is that correct?
Yes. Excuse
Okay.
me, yes.
Okay. So as we're filing a divorce today, in the event that the judge failed to grant the divorce, would you and Richard go back living as husband and wife?
No.
Are there any minor children born during the marriage?
No.
And are you currently pregnant?
No.
Okay. As it relates to the consent judgment of divorce, you've had a chance to review this document. Is that correct?
Yes.
Okay. And Mr. Hobig has also had a chance to review this document.
Yes.
Okay. And the two of you have actually had conversation back and forth regarding some of the specifics that we addressed in the judgment divorce. Is that correct?
Yes.
Okay. And he also voluntarily signed this judgment. Is that correct?
Yes.
Okay. And just for the record, he did come to my office and I'm familiar with Mr. Hobig and I did witness him sign this judgment, review it and sign it. Just to touch base just briefly on an outline of the judgment divorce as it relates to real property. Both you and Mr. Hobig have a lot of property together. Is that correct?
Yes.
Okay. However, back in the when we entered the separate maintenance back in 2017, you guys incorporated a property settlement agreement related to those properties. Is that true?
Yes.
And basically what we did here is we restated pretty much verbatim that particular agreement into this judgment of divorce, but we did make a few minor changes.
Yes.
Okay. Basically, as an overall umbrella, as it relates to real property, you are going to be awarded the North River Road property.
Yes.
And then basically he's going to be awarded all the other properties. However, there's agreements that were put in place after the separate maintenance was entered, where the two of you agreed on how he's going to pay back all your equitable interest in those properties.
Yes.
Okay. As it relates to the vehicles, you're keeping the vehicles in your possession. He's keeping vehicles in his possession.
Yes.
As it's related to the marital debt, he's going to be 100% responsible for the Huntington Bank card and the Bank of America line of credit.
Yes.
Any type of bank accounts, each one of you are going to keep your own.
Yes.
As it relates to the business, he has a dumpster company business and a few other businesses he actually acquired after the separate maintenance was entered until now. However, both of you agree that he's keeping 100% of those businesses, both assets, any liabilities, whether occurred now, prior, or in the future.
Correct.
Okay. As it relates to retirement accounts, if either of you hold those retirement accounts, whether it be a pension or 401, each of you will keep your own.
Correct.
You've both agreed no spousal support is going to be awarded to either party.
Yes.
And you understand that if you don't ask for that now, it's forever barred.
Correct.
And at this point, you're going to keep your last name of Hobig?
For now, yes.
And you understand, change it in the future, you'll have to go through like probate court to be able to do that.
Yes. Thank you.
Okay. And so do you believe the judgment reflects all the assets and liabilities that both of you have disclosed?
I do.
Do you believe the terms of this judgment are fair and equitable?
I do.
Okay. Has anybody threatened you or promised you to enter into this judgment?
No.
I have nothing further, Your Honor.
All right. The court is satisfied from testimony jurisdictional requirements for divorce have been met. There's been a breakdown in the marriage relationship and based on reasonable likelihood of reconciliation. There are no minor children in marriage and the plaintiff is not currently pregnant. Division of assets and liabilities be according to agreement of the parties, and neither party will have an interest. The other party's retirement savings plan, pension plan, or profit sharing plan for army. Alimony payable from either party, the other be forever barred. And both parties having consented to the entry of the judgment, I'll sign it at this time.
Thank you, Your Honor.
Ms. Easter, you can make arrangements to get the copies you need from us.
Great.
You're all
Thank you, Your
set.
Honor. Thank you. Have a
Thank
good
you.
day.
You're welcome.
You too. Thank you, Your Honor.
You're welcome.
I have both parties for the 11 o'clock. No attendance.
Both parties. All right. Great. All right, this is Harm versus Harm. Are you Alexis Harm?
Yes.
Are you Dustin Harm?
Yes.
All right. Both of you raise your right hands, please, so I can see them. Each of you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Yes.
All right, you can put your hands down. Ms. Harm, would you state your name and your address for the record, please?
Alexis Marie Harm,
What's your address?
829 Beard Street, apartment 2.
Port Huron?
Yes.
Mr. Harm, would you state your name and address for the record?
My name is Dustin Joseph Harm. I live at 2315 Beard Street, Port Huron, Michigan.
2315 Beard?
2315 Beard, yes.
All right, because the judgment says 15th Street.
Oh, no, that, I don't know how that got messed up. I know it's 2315 15th Street. Well,
It is
Beard.
15th Street?
Yeah, 15th and Beard.
So it is Beard Street then?
Yes.
Okay. All right, Mrs. Harm, are you married to Dustin Harm?
Yes.
On what date were you married?
I think it was August 25th, I think. Can't exactly
You don't know?
remember.
What your complaint says is that your marriage took place on August 31st of 2013. Is that true?
Yes.
All right. Was that marriage performed, Ms. Harm, by a person authorized by law to perform marriages?
Yes.
All right, I have to ask Ms. Harm this because she's the plaintiff.
Oh, I apologize.
That's all right.
What was the question?
Was your marriage performed by somebody authorized by law to perform marriages?
Yes.
Prior to filing your complaint for divorce, were you resident of the state of Michigan for at least 180 days?
Yes.
Were you resident of the county of St. Clair for at least 10 days?
Yes.
In your complaint, you allege that there's been a breakdown in the marriage relationship and there remains no reasonable likelihood that union can be preserved. Is that still true?
I'm sorry, I'm having trouble hearing over the Zoom.
Your complaint, you indicated that you have your marriage has been broken down to the extent that the objects of matrimony cannot be preserved. Is that still true?
Yes.
Are there minor children in the marriage?
Yes.
How many?
2. And then one that was born into the marriage after we separated already for a while.
Have you had a paternity test done on that child?
Yes.
You did not submit a copy of that to the court.
I gave them a copy of it and they and I thought they gave it to you because they gave me another one back after I picked up the judgment, but I did turn in one with the judgment, but she said after she gave me the pre-recipe, she gave me it back, so I thought she copied it.
Let me just look at what I've got here to make sure. do have a copy of a DNA test report that's attached to the child support order, not the judge. Is that Haley Green, born on the 7th of March of 2019?
She was born April 14th, 2014. Yes, Haley Green.
2014.
Yes, April 14th.
All right, I'm sorry. You're telling me that the child was born before the marriage?
No, she was born after me and him already separated, but we weren't divorced. So in the state of Michigan, we're still married when she was born.
All right, now you're confusing me because your complaint says you've been married on August 31st of 2015, but you're telling me this child was born in 2014.
No, that's Jared. Jared was born in 2014.
I'm talking about
Haley
Haley.
Green was born in April of the 2018.
2018?
Yes.
So how many children were born during the marriage, including Haley?
3.
We weren't married when Leon was born. We just had Jared.
Hold
Are
on
you
a
sure?
minute. Hold on a minute. The two of you, just wait a minute. Give me the names and dates of birth of all 3 children.
Leanne is 6/17/12. Jared is 4/2/15. Yeah, and then Haley is 4/14/18.
And what was the date of the middle child again, Jared?
Yes,
What was the date of his birth?
4/2/15.
18.
8.
Mr. Harm, you're indicating a different date. Don't you know when your children were born?
Yes. I get
So what's
mixed up with
what's
when
the
we got.
date of birth? What's the date of birth of Jared?
Jared's 4/2/15.
And the date of Haley?
4/14/18.
So both Leon and Jared were born before you were married, correct?
Jared was born after we were married. Leanne was born before we were married.
Wait. No, not the date, by the dates you just gave me. If Jared was born in April of 2015 and you weren't married till August of 2015, he was born before you were married.
He was born 4/2/15. Did we get married before that, Dustin? Because I could have swore it was between both of our birthdays. It's August.
I believe we
Look.
got married in 2016. I can pull out our marriage license.
Because Jared, I know he's 4/2/15, but
Let me just cut to the chase here. Mr. Harm, did you sign an acknowledgement of paternity for these 2 children?
For Leon and Jared, yes, sir.
So you signed an acknowledgement of paternity for both children?
Yes.
All right, you wouldn't have done that if you'd been married at the time of the birth of the child. What is your agreement as it relates to the custody of those 2 boys?
I'm their father.
No, I said custody.
Oh,
Your judgment of divorce provides that the plaintiff will have legal custody and the plaintiff will have physical custody.
yes.
Is that your agreement? That's your
Yeah.
agreement, both of you?
Yes, sir.
Ms. Harm?
Yes.
All right, and you agreed as it relates to parenting time, correct?
Yes.
Do the two of you believe that your agreement is in the best interest of your two children?
Yes.
Yes.
Ms. Harm, are you pregnant now?
No.
Do the two of you own any real estate?
No.
No.
When you separated, did you divide all of your personal property?
Yes.
Yes.
Do you have any joint debts between the two of you?
No.
No.
So you'll each be responsible for any debt in your own name, correct?
Yes.
Yes.
Are there any pensions or retirement savings to be divided?
No.
No.
Is it true that neither one of you will pay the other spouse's support?
I'm
Is
sorry.
it true that neither one of you will pay the other alimony?
No.
We're not
That's
paying.
not true.
I don't think we're paying alimony.
I don't think so
Listen to
either. I
the-
know you pay child support.
Ms. Harm, listen to the question, please. Is it true that you're not going to receive or pay alimony?
Yes.
Mr. Harm, is that true?
Yes.
Ms. Harm, are you asking to have your name changed?
No.
All right. Court is satisfied from testimony jurisdictional requirements for divorce have been met. There's been a breakdown in the marriage relationship and there remains no reasonable likelihood of reconciliation. There are 3 minor children born during the marriage. A minor child, Haley, is not the issue of this marriage, as has been shown by a DNA test showing that another individual is the biological father of this child. As it relates to Leon and Jared, the mother will be awarded sole legal and sole physical custody of the minor children. Parents have agreed on parenting time. They've also indicated to the court that they believe this is the best interest of the minor children, and the court will make that finding based on that testimony. They've already divided their assets and liabilities. Neither party will have an interest in the other party's retirement savings plan, pension plan, or profit sharing plan if there are any. Alimony payable from either party, the other be forever barred. Both parties having consented to the entry of the judgment of divorce has been reviewed and approved by the friend of the court. I'll sign it at this time. What was the, never mind. All right, we're gonna have this filed with the county clerk's office. You can get copies, once that's been done.